Good morning or good afternoon. It is my pleasure to present to the audience of Euro-Nano Forum 2021 the key findings from the first legal workshop organized by the H2020 funded project SABYDOMA. I'm Anthony Bochon, a lawyer based in Brussels, partner at law firm Gil Robles and Bartolome & Partners, and with my team we are dealing with the legal aspects of the SABYDOMA project. On the 28th of January this year, we had the opportunity to bring together lawyers and scientists, and we explored potential definitions of safe by design approaches from a legal perspective. That was probably the first legal workshop ever devoted to safe by design approaches. Among the speakers, 3 of them underlined that safe by design should be understood in a very broad manner and that we cannot isolate science from other factors such as economic, cultural, political, but also legal constraints. On top of that, trying to define legally safe by design means that we need to base our scientific approach on interdisciplinary measures, and that we should take into account the point of view of experts from different fields. The key findings of this first legal workshop were threefold. First of all, there is a disparate regulatory environment. Secondly, there is no legal definition of safe by design. And thirdly, although safe by design approaches in the field of nanosciences are new and innovative, we can draw very interesting comparisons with other legal approaches, and among them, the privacy by design principle is the first one we think about. The disparate regulatory environment is a key finding from this first legal workshop. In most jurisdictions in the world, there is no legal definition of nanomaterials at all, and there is even no legal framework addressing nanosafety issues. We have here the example that in Asia, only South Korea has a legal system that adopted some measures specifically devoted to nanosafety. In the European Union, the situation is different. During the last 15 years, the European Union has been legislating in different sectors: food, cosmetics, biocides, medical devices, but also chemicals, and tried to build a comprehensive legal framework for nanotechnologies and nanomaterials. However, we have seen that with some national initiatives, such as the nanomaterial registers adopted in France, Denmark, Belgium, Sweden, it is not self-evident who is the best placed legislator, and there is also a conflict of competence between member states and the European Union. But there is clearly a conclusion. With this disparate legal environment, there is no unique legal definition of terms such as nanotechnologies, nanomaterials, or nanoforms. And we have seen political institutions struggling on a potential agreement about a single legal definition, which was promoted a few years ago by the European Commission. With this disparate regulatory environment, we have, of course, no surprise. There is clearly no legal definition of safe by design for the time being. But if we look a bit further, we see that at least in the European Union, in previously adopted legislative instruments, the concept of a safe by design approach was already mentioned in several instruments. So it means that, in fact, there is nothing new under the sun, but much more something specific to the field of nanosciences. And specifically, if we think about potential areas of development for a legal definition of safe by design, we came to the conclusion at this first legal workshop that in the European Union, but also other jurisdictions in the world, the precautionary principle is protected by fundamental treaties and instruments and provides the best legal basis for further political action to implement safe by design approaches in sector-based or transversal legislation. On top of that, we have of course other key provisions, for instance in the Treaty on the Functioning of the European Union, which can help the legislator to legally define safe by design. For instance, the requirement that there should be a high level of protection of human health or of the consumers. Thirdly, we had the very interesting opportunity at this workshop to discuss about potential sources of inspiration. With Professor Ira Rubinstein from New York University School of Law, we explored how the privacy by design principle, which has been implemented a few years ago in the General Data Protection Regulation adopted by the European Union, could serve as an interesting comparison source, and especially how lawyers have drafted and implemented a by design approach, though in another technological field. And that is a very interesting source of inspiration. And we see today with circularity by design, which is also discussed, that by design approaches can be implemented in regulatory policies. But after this first legal workshop, we didn't think that we should stop the work here. On the contrary, we have a perspective that although there is currently no legal definition of safe by design, there are potential areas of growth. There are, of course, certain risks that should be taken into account, certain non-legal factors that should be taken into account. But the conclusion from this first legal workshop was that we can still think about potential legal definitions. The precautionary principle is key, and together with members of SABYDOMA project and also attendees and speakers from this first legal workshop, we will further work in the next months on a green paper devoted to the legal study of safe by design approaches. If you have any questions, any queries, any suggestion, please feel free to reach out. My contact details are here, and I will be happy to answer to your questions and to hear what you have to think and to suggest about the safe by design approaches from a legal perspective. I thank you very much and hope you will enjoy your attendance at Euro Nano Forum 2021. Goodbye.